Good afternoon, everyone. The judges will be arriving in another 5 minutes. So it's a kind request for everyone to wrap up and please be seated. I would like to notify everyone once again that the judges will be arriving shortly. So please wind up and take your seats. A quick announcement. Participants are requested to be seated ahead, and our volunteers and students from St. Joseph's College of Law kindly be seated in the last few rows. So please make a note of it. Team managers, kindly sit with your teams so that it'll be easier for them to, uh, come on stage when announcements are made. But other volunteers, kindly occupy the seats in the last row.
Hello. I kindly request everyone who is sitting behind to occupy the seats in the front. All the vacant seats in the front, irrespective of the teams and team manager, all the volunteers plus all the audience, please occupy all the vacant seats in front. Good afternoon to all. I request you all to rise as the dignitaries enter. Kindly please rise. Now, I request the honorable dignitaries to please take their seats among the audience. Kindly sit. Once again, welcome everyone. After 2 days of intense competition, we are finally here to witness the finals. Now, I invite the best among the best, our finalists, to the dais for one last round. As I call out the names, I kindly request the participants to occupy the stage. Requesting party, Team Code 23, Muskan and Ali. Responding party, Team Code 18, Geetanjali and Vanshika. They will be accompanied with mediator number 1, Team Code number 1, Narmada. Mediator number 2, Team Code 25, Saranya. I request the participants to rise as the dignitaries enter the stage. Now, I request our judges, Honorable Justice Sri Hanchate Srikumar, Sanjeev Kumar, and Dr. Satish Srinivasan to take their seats on the stage. I also request Mr. Shankar, our timekeeper for the day, to take his seat on the stage. Everyone kindly sit. Now we are going to begin our finals at 2:20. We are ready with the rounds. We are starting the final right now.
So, am I audible? A very good afternoon, everyone. I hope everyone is comfortably seated. You're healthy, have had your lunch, maybe not so happy, which we will sort today. And I really hope it wasn't much of a hassle in finding the center. I'm Saranya. With me, I have your co-mediator, Miss Maya. We will be mediating your session today. Parties, at the outset, I would like to clarify that both of us are certified mediators from the International Mediation Institute and have about 10 years of experience in this field, especially commercial law. So you are in safe hands. And also, parties, I would like to take this moment to thank both of you for actually committing to this session on a Saturday afternoon. That is a weekend. I know that this might not be the most suitable day to discuss this dispute, but your willingness itself shows your positive approach. So let's take this momentum forward. With that, parties, just so that we are aware, this mediation proceeding draws its validity from clause 6.1 of your agreement. Am I correct? Thank you, parties. So for the sake of clarity, I kindly request both the parties to introduce yourself briefly. Please state your role and your position. And an additional questions to the client is whether they have the requisite authority to take decisions on behalf of their company. Parties, please note that this is just your introductory statement and not your opening statement. The requesting party can begin.
Thank you so much, Ms. Mediator. I am Muskan Mishra, and I would be representing NovaCap Capital. I assure you that I have full authority and capacity to enter upon any decisions that we reach today in this mediation session.
Right. Good afternoon, everyone. This is Ali Muswi, and I shall be representing Ms. Muskan as a counsel. And I'm certain that she has all the will, authority, and more than that, all the heart to come to a consensus today. So,
thank you, party. Who do we have from the other side?
I hope I'm audible.
Yes.
I am Gitanjali, and I am from the Ministry of Digital Infrastructure of Samridhika. And I would like to reassure at the very first instance that I am entrusted with all authorities to make any fruitful decision that we may come through this session. I look forward to an open session.
Good evening, everyone. I am Vanshika. I am the counsel for the government of Samridhika, and I am here on the advisory capacity. Thank you.
Thank you, party. So having done the introductions, a small suggestion from my side would be that since this session is going to last for 1.5 hours, please use your water bottles. So with that said, I can see that the issue is very important to both the parties. So let's set some key features of mediation process. I'm pretty sure that the counsels have already briefed your clients, but this is just the mediator's duty to do so. Since I can see from your faces that the session is very important, confidentiality naturally becomes an important aspect. Both the mediators assure you that this entire session will be completely confidential. Anything said within the four walls of this room shall not go outside. And this confidentiality clause is also mandated by Article 6 of the UNICITRAL mediation rules and Article 9 of the International Center for ADR rules. So again, you're in safe hands. Secondly, parties, you have come here voluntarily. You have the authority to quit voluntarily with any type of resolution or settlement you like to. And thirdly, this is a non-prejudicial forum, party. So whatever you state here cannot and will not be used against you under any court of law. Lastly, I would like to end my opening statement with a small analogy which reflects our role as a mediators, which is a neutral third party. I am a part-time guitarist. So for me, mediation is like playing guitar. What do you need to play guitar? 2 hands. And here, only when both the hands work in consonance with each other and cooperate with each other, a beautiful music will come. If not, the music that turns out may not be so ideal. So you both are the 2 hands and you have the crucial role of mediating successfully. But sometimes you may go out of tune, where us as the mediators come as the guitar tuner for you to rescue. So now I would like to pass it to my co-mediator.
Thank you so much, Saranya. And thank you, parties, for trusting mediation as a mode of settling your dispute. As my co-mediator was explaining mediation process, I would like to ask, have you been to a mediation before?
No, we have not.
Okay. For the sake of the other party, as Sharanya was explaining, let me just take it over. So mediation process is where you have a dispute. Let's say you have different pieces of a puzzle. And what we are going to do as a mediator is, we are not going to tell you which is the right, which is the wrong, or how to force it together. What we'll be doing is, we will ensure that you have a smooth conversation, we'll facilitate towards it, and we are very neutral to this. We are neither with party A or party B, we will remain neutral, and the decisions which are made will be yours and not ours. Is that clear?
It is very clear.
Okay. So as the co-mediator was telling, we have 3 rules in mediation. The first pillar will be active listening. First, respect each other's boundary, and second will be the confidentiality clause, which as my co-mediator already mentioned, and this is totally voluntary. So all of this with our neutrality is the essence of mediation. With that said, we have our NDAs here, duly signed by the mediators. We request the parties also to sign it for. As you know, it is a voluntary process and it is an informal process, but still it will be good for us to set some ground rules. The ground rules will be, each party will be given enough time to represent your views without interruption. And as I mentioned, active listening. And we maintain our decorum inside this room, and we respect each other while conducting ourselves better. Is that clear? And feel free to reach out to us if you need anything, any breaks or anything that you would require anytime. And talking about the structured process, we have a structure in hand. Both the parties will be given time to give your opening statements, followed by fixing agendas by the mediators, which you can have the possibility of amending if you need something to be changed in the agendas. And we'll go on discussing those agendas, and hopefully we come into some agreement within this mediation session. Is that clear? And there is something additional. There is something called private caucus. If the parties feel that you want to discuss something in private, which you don't want to disclose it openly, please feel free to call a caucus with us. And we mediators, if we find that there is a necessity to call for caucus, we will also do the same. Is that understood? Is there any point of clarification that is needed at this time?
We are good. Thank you.
Thank you so much.
Okay, so parties, I think we are good to go for your opening statements, but just before that, we would like to clarify that since this is an international forum and it is a cross-border dispute, we understand that English might not be everyone's first language. So I highly encourage both the parties to please speak clearly and loudly so that everyone understands. Also remember, you can never shake hands with clenched fists, so please have an open-minded understanding. Yes.
Also, mediators, we will be here to summarize or clarify whatever the other party is not able to understand. So feel free to actually discuss the dispute so that we arrive somewhere in the middle ground. So mediation is all about collaboration, compromise, and finding a middle ground. That is why we are here in this room. Let's make the best out of the time which we have. And I request the requesting party to start with their opening statement. Thank you.
Thank you so much, Saranya and Maya, for putting down the method and the simplicity of mediation so eloquently and simply. Secondly, I also thank the responding party, that is Samradhikan's government, for being here and accepting our proposal to get this decision through mediation. Moving on, I really appreciate the fact that musical symphony and guitar was mentioned, and I believe that by the end of this mediation session, we would definitely find a musical tuning to this particular dispute. Moving on, apologies. NovaCap, right. I am the representative of NovaCap. NovaCap has always upheld the principles of responsible investment, financial prudence, and long-term stability in our dealing. We have always been an economic powerhouse that is known for a strong investment. However, we are at this juncture wherein we believe that there are certain financial restraints or sudden policy changes in Samradhikan government has impacted our dealings immensely. And we believe that this particular change in policy has financially affected us a lot. Because considering the fact that while this agreement was entered upon, significant amount was invested in Samradhikan government in order to facilitate this agreement. However, we have, I feel, found ourselves in certain murky waters where the future seems a little blurry and the present is also very uncertain. So, as and when we have our demands and rights ready to put forward, we realize that this session is a mediation session. We remind you that we are here with a clean slate, and we will make sure that we uphold our professional values during this mediation session, and make sure that we don't just put our needs forward, but also cater to the needs and reach a reliable solution which would help us grow immensely. Over to you, Mr. Ali.
Thank you so much, Muskan. Before that, you referred to the new law, new policy. Are you referring to the Data Integrity and Sovereignty Act?
Yes, that is correct.
Thank you for the clarity. Thank you.
Right. Firstly, again, a very good afternoon here. Firstly, at the outset, thank you so much, both the mediators, for explaining the entire mediation process in such a straightforward and intricate manner. I think it has laid down the ground rules and has decluttered the entire session in a way more simple manner. Secondly, thank you so much to the representatives of the government for accepting our invite and joining us at the mediation session. I think our presence in this room, our presence in this session in itself is a productive start, a great start, a good head start, and I think that we will be taking this ahead by leaps and bounds. Now, as we were heading here, both Ms. Muskan and I were discussing that whenever a government is involved in any capacity in any industry with alongside a private entity, there are two things which are very critical, something which has to be kept in mind. First is the trust between the private entity and the government, and second is the public welfare or the public responsibility that the government keeps in mind with when they are conversing or interacting in any capacity with the private entity. Keeping both these things in mind, we also have to take into cognizance the role of regulations. These regulations, and we are not new to regulations. Ms. Muskan and I were discussing that there are several countries where investments play a critical role, and every government has their own set of regulations. The only point of where we have to, in a way, concentrate is that these regulations should not turn out to be roadblocks for development and progress. So keeping that in mind, as Ms. Muskan and I were discussing, we came up with certain proposals. We came up with certain interests, agendas, and proposals, which we will be laying forward with your permission and with due permission of Ms.
Yes, please.
Saranya and
Please go ahead.
Maya. And before that, the interests which I wanted to lay down were these. The first being addressing financial and operational uncertainties. The second being seeking practical realities, practical remedies. And third being establishing a framework for future engagement.
Trademark.
Sorry?
Establishing?
Establishing a framework for future engagement. One thing which Ms. Muskan and I, after speaking to Ms. Muskan, we wanted to make it clear was that we are here to take this ahead. We are here to take this collaboration ahead. But whatever the constituents of that might be, should be given a closer look. With that being said, we have certain proposals, but I think we'll park them for the moment, and we are really curious to see what you have in store for us. So over to you.
Thank you so much, NovaCap, and you can take over.
I really appreciate that. But before I proceed, I would like to thank the mediators for setting this environment and really giving us the confidence that we might reach to a solution. Moving forward, thank you for inviting us to this table and this occasion where we can actually discuss where you're coming from and where I am seeing things go. What I would like to, another thing that also I appreciate is the Saturday evening. I know, and that also shows me how urgently you want to solve this matter and that you are holding this in very high regard, and that is something I personally resonate with. Now, AI has been the thing. It is the new thing. Data transparency, data transactions, data storage, all are playing a big role in the global environment. As such, and as per our negotiations, as we discussed before entering into the agreement, this was something that we really wanted to establish, which is why we entered into a contract with NovaCap, right? And NovaCap was also entered through a bidding system where they had won the bidding system. So as far as my understanding goes through the agreement is that we have launched a project DVault on behalf of the government, which is to serve as an AI startup, a venue, and as well as for global infrastructure, cloud infrastructure, I correct myself. And our agreement in specific with NovaCap is restricted to data infrastructure providing. Am I right?
Correct.
Yes. So, and we have established that there are 6 data centers that you will be providing. Am I right?
Yes.
Yes. And a total consideration of $500 million shall be invested into this particular avenue or investment by Novacap over a period of 10 years. So what I would like to emphasize on, and as they brought up, is my public responsibility. Just like you are responsible to your investors and your other shareholders, I hope you understand the gravity of my responsibility. It is just not investors, personal stakeholders, and as well as my citizens' security and safety. And these are 2 things that I cannot compromise on, and I hope we can keep that in mind as we go ahead. Having this as a base, I think my council has more to add on.
Thank you, Gitanjali, for explaining that very well. And thank you, mediators, for agreeing to assist us. And I thank opposing party for requesting this mediation. I think it was a great idea. I highly believe that in legal world, there are different perspectives, and it's important to see all the perspectives. Mediation is the way through which we can see beyond black and white of law and tap into the gray areas of law where we can see the heart of the matter. And I feel this mediation session would be fruitful towards that. Whereas my client Gitanjali has very eloquently put forth her points, I would like to summarize it for you. So firstly, that as a country, we focus on national security. We cannot expect to compromise on the national security of our nation. And secondly, for doing that, we would require some transparency from your end. And with that in mind, I would look forward to this session. Thank you.
Noted parties, thank you so much. Just before we proceed, we would like to ask if the responding party has any specific agenda in mind.
If I may, as I recognize how important your agendas are also, but given that I feel we're at a middle ground per se. First thing that to be specifically mentioned is the local ownership that is of our primary concern. Second, we are open to discussing practical remedies as you had suggested. And as far as the framework, I feel there is an existing framework within which there are certain possibilities for collaboration which we can explore.
Understood, party. So if the mediators may just recalibrate the agenda that is given by you, would you like to? Just give us 2 seconds and we'll recalibrate the agenda.
Sure, thank you.
So both the parties, after hearing your opening statements, we have set 3 agendas. So first one will be, in no particular order, compensation and financial settlement, about your financial compensation, that will be discussed. And next will be the practical remedies, under which, as the party requested, the local ownership will also be discussed. And the third one, which both want to discuss, is the future cooperation of your agreements. So the party is okay with the agenda, or is there anything that you need to be added?
If I may just interrupt, I feel as far as the financial compensation goes, I feel what are the practical remedies we can come through is important. That's when we can decide how much and how the money will flow between the parties. So I just hope we can move the second agenda to being the first, and then...
Yes, parties.
If
So
that is okay with the...
I apologize, but I think as of right now, considering the fact that there were sudden policy changes that were made and has impacted our company at a financial level. And for us, I think discussing how we could figure out a way wherein our company is restored is very important to us, and maybe explore certain proposals or options considering that, if that is okay with the government.
yes, so you have given your suggestions. So what, as co-mediators, we feel is, it is better that we have 3 agendas in place. It is not necessarily we have to go in any particular order. Let us discuss and see where this goes. I'm sure at the end we will be able to come to our agendas back at the decisions which you arrive. It is more about you both negotiating, conversing, and arriving at a mutual ground. So forget about the agendas, keep this in your mind, but focus on arriving at a mutual ground rather than agendas per se. Is that okay for both the parties? With that said,
Okay, so parties, I understand you, the same thing as my co-mediator said, you have set for financial compensation and you are asking for a practical resolution. So this can be clubbed. Like my co-mediator said, there's no particular order. We understand that different things are of different importance and weights to you. So you can club that and discuss. Is that okay? So just before you delve into it, I would like to state that we highly encourage both the parties to approach this with a spirit of collaboration. Listen to the other party, not just to respond, but to understand their side. So because you have to work together is what we gather from your opening statement. So you have to build a path of trust in the future. If that is okay, you can get the ball rolling and you can discuss with the first agenda. Please go ahead, parties.
any party can begin.
Is it okay if I may? Great, thank you so much, Ms. Saranya and Maya. So firstly, what I would want to discuss is that when we got into this agreement, we made sure that around $280 million were invested in this particular data centers. We made 3 data centers out of which, and 2 more data centers that were under construction. Now, due to the policy changes that have recently been brought, the 2 data centers that were under construction were suspended, due to which we faced immense losses. Because right now our capital has sunk, like the capital that we invested. Our investors are at stake. They are the ones they are questioning as to how we could get into certain relationships wherein such uncertainty would arise. We understand that, I believe, before we kick-started this session, Mr. Ali was explaining how there can be legitimate expectations. However, we believe that legitimate expectations are something that can be foreseeable, but a sudden change in the regulatory framework was unforeseeable. And we believe that this has put us in murky waters, and we were hoping that if there's a way where we can find out underlying reasons, apart from the national security reasons that were stated by you, we were hoping if there are other underlying reasons that we would like to understand in the manner wherein we could go ahead and find a resolution to this.
Right. So, as Ms. Muskan stated, see, when any private entity or any investment for that matter is coming into any state or any nation or any country, they have certain expectations from the government that in situations when there are certain unforeseen circumstances which might come up, how will they cooperate with the government? How will the private entities collaborate with the government? Now, in this scenario, and we respect that, as you rightly stated, that you have to take care of the safety and security of the citizens. We are completely, we completely agree with that point. However, when these sort of unforeseen circumstances arise, we have to ensure that the private entities who have put in millions and billions of dollars in any state or entity for that matter is treated not only fairly and justly, but if I may say, any arbitrary or any sort of unforeseen decision should not be made which will hurt us monetarily and financially. That is all we are asking. Just to summarize the point which Ms. Muskan stated about legitimate expectation, that any private entity for that matter will have certain expectations from the government, that in a certain scenario this will be expected, no arbitrary decision will be taken up. So that's all we are pointing out, because as Ms. Muskan stated, we are undergoing huge financial losses. So that is something which we wanted covered and capped.
So if I can summarize for the other party, they want to know if there are other reasons other than the national security. Is there any other reasons for all this mishappenings? And they expect a legitimate expectation. That is what you have been doing from the past. They expect the same. That is what legitimate expectation means. So they are asking, what is the reason? Can you please explain them?
Just before that party, I think they have said their side. You can respond to it, and after that we can move forward with a solution-oriented approach, because I understand that all of us are present in this room for the same. You are being given an equal opportunity to answer to their questions or clarify certain things. But however, after that, I request both the parties to see about the future of what you want to do. You can propose solutions, because that's why you're here. Please proceed.
Thank you, mediators. Thank you, requesting party. So let me just understand this. So your primary concern is legitimate expectations. financial costs that have been incurred during this time. Okay, so let me tell you. AI has been developing, and we all see that, but it's a developing technology, right? It has its own faults, loopholes, etc., which we all know. And the recent cyber attacks and hijacking of data is not something that is not been disclosed. It's very public information, right? And multiple countries have been seeing this. And let me just remind you, we are a developing country. Our priority is always to protect our people, right? And as far as legitimate expectation goes, it is always prevalent on the current circumstances. Just because some circumstances existed previously does not mean they shall exist in the future. And it is our responsibility as the government to take immediate action, right? So that is something we have taken into consideration. And we respect you as a partner, or else we wouldn't have entered into a 20-year-long partnership. I hope we agree on that,
Definitely.
right? So this is not something that we have brought in to discriminate you or put you at a negative aspect, but given the gravity of the situation and the responsibility on my shoulders, this is something I was forced to take on to, right? Nonetheless, I believe there are ways we can work within the existing structure, and I assume that you have solutions to bring forth. My counsel would like to add a few more points.
Adding on to what my client just said, like we previously mentioned, this relationship is built on trust, right? And to establish this trust, we have given you our public-private data. So you have already processed the 40% of this data, and we know in today's world, data is money. So we are indirectly investing in you. And we are also accountable to our citizens. So with that in mind, if you move forward to the transparency aspect, that would be great.
As much as I appreciate whatever has just been stated, I want to remind you that there are no negative intentions from our side. We are not questioning your integrity or your state right now, because we understand during national security concerns, if this were a case in our own industry, we would have taken certain actions that might have had an impact. So I want to remind you and assure you that we are here on a clean slate and want to discuss this openly so that we regain that trust. And I believe there has been a mutual breach of trust. However, we're glad that we started off on a positive note, considering that both have been impacted. And in addition to that, I think my questions were answered very clearly. My counsel, Mr. Ali, would now look into the proposals, and we can maybe move ahead and discuss those proposals.
Thank you, parties. I think we are somewhere on the same foot, that both of you are acknowledging what has happened. Yes, counsel, please proceed.
Right. So with the permission of Ms. Sarani and Ms. Maya, I'll go ahead and present the proposals. Just before the proposals, and as Ms. Muskan stated, I wanted to just clarify on the legitimate expectation point. So with respect to the legitimate expectation, we were seeing it as an administrative law doctrine. We were not looking at it as a sort of a stipulation in the contract. All we were stating is that whatever action we take today at the end of the session or at the end of the day, it should comply with the legitimate expectations that any private entity has. Now, with respect to that, no arbitrary decision should be taken, which will put us in a disadvantageous position. That's all we wanted to put forward. With that being stated, I wanted to present the proposals, if I have the permission.
Please proceed.
For the sake of clarity, could you
I will.
also tell us a proposal so that it can be discussed?
So there were two reasons of getting up this proposal. First, that we move towards a solution-oriented discussion. And second, that this proposal acts as an anchor to our session today, so that we don't waste any time with respect to the technicalities. Now, with respect to the proposal, we have brought 3-4 points. The first being a true 2-year transition plan for NovaCap's exit, if at the end of the day, which is clause number 2 in the proposal, which if at the end of the day we are not able to materialize with the collaboration which we were targeting. The second being a joint cybersecurity task force, because as you rightly stated, data is money, data is gold. Today the data is a new elixir. So with respect to that data, I think we need to get certain data experts and other, task force members, so that we not only protect the data of the citizens of your country, but also with respect to the proprietary rights and other technicalities, are, in a safe position. The third being the non-disclosure and liability protection clause, and the fourth being the the split of the data operation split. Now, these are, few technical terms, but I will very, in simple words, I will take you all through, and we would be really delighted if you could, revert back on this, and, we can discuss on this, if with your permission, Ms. Aranya and Ms. Maya.
Since we identify the problem here, and party NovaCap has actually proposed certain proposals, is the other party okay to discuss the proposals, or you have anything else to add on to this?
First of all, these are very great proposals, and I do appreciate you for bringing it forward. I feel there are certain provisions that we probably will like to discuss on, but I would like to first hear where you're coming from and your reasoning behind your proposals before I go ahead.
So to give you a rationale behind why we have come up with these proposals is that, firstly, we, like I have already stated, we are running in losses. We do not have the investor confidence as of right now. We need to get our investors back on state, and we cannot be continuing in an environment that does not support our mechanism. Because currently, within the manner the policy has come up, is impacting us, because I don't think in the near future would be able to hold, or even right now can hold, the shares that we hold of this particular agreement. Because according to the, I think, policy, one of the points was that it has to have Samriddhikan's local government, it has to be held by Samriddhikan's local owners, and we are not a local. I mean, as much as you treat us as one, but we are still foreign, and I believe that such an application or such a policy change has a very huge impact on our finances. And I believe that financial compensation is something we need to focus on right now, because we already have invested a lot of money, we're running in losses, and we want the government to understand, as much as we respect the fact that there's national security, there is, at the end of the day, agreements have to be upheld, because these are contracts, these are not just random papers that we agreed upon.
So for clarification, can you please tell us what are the other losses that you have faced other than financial loss?
The very great loss is investor confidence. We are losing out on investors. They're questioning our capability. They are stating that, I mean, such big, the project that we have with Samriddhikan's government is one of the largest private venture in Asia. And when such a huge private venture is questioned, it also questions our integrity and our reputation in the market. And I believe we need to protect that.
So you feel like your goodwill is affected?
Definitely.
Beyond financial losses,
Yes.
if I'm right?
Yes.
Thank you.
Understood, party. I think we can take this step by step. Since they've proposed one part of it, you can reply to it instead of clubbing everything at once. So basically, if what we are understanding is this was a public-private partnership and you're a foreign country.
Yes.
However, due to changes in certain governmental regimes, you are not able to do the delegated work because a local owner is required to do the same, and however, you're not a local owner. Correct?
No, but I think the local ownership part which Ms. Muskan stated was with respect to the localization of data and
Understood.
the other, things. So I think, yeah, with respect to that, yes.
Clear, counsel. Okay. You can go ahead.
We'll give them a minute.
Right. So we would like clarification on the financial aspect, like how much money exactly are you seeking for?
Okay, so we had invested $270 million at the start, plus the $380 million that we are currently facing because of the losses. So all in about, I think my counsel can do the calculations because I don't deal into the numbers.
The total number of the agreement was around 500 million. Out of 500 million, we have invested 270 million. Now, that was the investment which we already was liquidated. Now, this number of 270 million has risen up to 380 million. Now, these are due to several, sort of stoppages, certain delays, suspended, licenses, opportunity cost. A lot of things has brought us this number to 380 million, which is quite a substantial amount looking at the long-term agreement we had signed and the total, the total financial agreement which we had entered into. So 380 million is the figure which we wanted to,
So your contract value was 500 million, and the current loss which you are facing because of all of this backlash is 380 million. Is that right?
That's right.
270 was the invested amount.
Yeah, so
your demand, just a
I
second.
apologize.
Yeah, not an issue. So your demand is for 380 million
Yes.
or an ask. Is that clear to the responding party, or would you want us to clear? Yes, you can please respond.
As much as I appreciate the clarity and transparency on your end, what must be noted is that out of the 6 data centers, 3 are already operational.
Right.
Is that, am I clear on that?
There were 5, out of which 3 are operational, 2 are under construction.
There are 6, 3 are under, I'm talking about the total contract was for 6 data centers.
Right.
3 are operational, 2 are under construction, and
With
We'll
respect to
provide.
that, I believe we are still in the in process. We have invested money, but the construction is yet to start. However, there have been forces deployed at the 6th construction site.
Okay, I understand that. Thank you for that. So how I would approach the financial matter is, in the 3 operating centers, there is already some financial data transactions that are already happening. And as far as I understand, both governmental and private data have been stored there, and that is how those centers are operating. So you're getting both your financial sources for that particular 3 centers have been the governmental as well as private sectors. Am I right? So this is why. This is where I would like to bring a different aspect to your compensation aspect, right? My intention is to continue with this contract, right? But I need protection for my data, and especially for my citizens' data. But we are having a shared infrastructure in these 3 centers, and the rest 3 also will follow the similar pattern. This is one thing of primary concern for us, which is why we don't see how exactly that number is coming up, because they're already earning money. It's not like has been no financial source for those 3 centers. There has been some financial income, correct? And given that 40% of the public data is already under operations with you, there's also a substantial amount of data which is coming from our end. So you understand where I'm trying to come in interest of my people.
If the mediators could just summarize what has just been stated.
All right. So since the responding party is representing the government, they are not clear as to how the 380 million amount is reached. Number 1, because out of the 6 data centers, you may please correct me, because out of the 6 data centers, 3 data centers are already operational, and there is revenue generation of the 3 data centers already being made. So they want a clarity as to how the 380 million amount is reached, because representing the government, they took the step to safeguard the data and privacy of their citizens. Is that correct, or would you like to add anything?
I think they would like to have the breakup of your 380 million of losses. How did you arrive at that number?
Or any negotiation, it is up to you.
Ms. Muskan? When we say that there are 3 operating data centers and 2 under construction, and both of them are earning financial funds and all of that, that's absolutely true. And it would have been going brilliantly well had not the DIS Act come in. The problem begins after the DIS Act kicks in. Once the Act kicks in, the several clauses and several stipulations, which both of us had mutually agreed to, is thrown in an arena of question and doubt. That has thrown us in a question of apprehension, because once the DIS Act has come in, several things which we had agreed to we are not able to comply on that. Now, because we are not able to comply, we are not able to earn the revenue we had targeted. That is how the losses have started incurring.
To correct me if I'm wrong, so you're trying to tell that because of the DIS Act, the repercussions have resulted in your financial losses.
Exactly. Had there been no DIS Act, then I don't think we would have been even sitting here in this mediation room.
Understood, party. Just a clarification. Now, after the introduction of the DIS, the remaining 3 centers which are actually operational, are they still operating, or are they operating at a loss, or are they not operating?
Reduced capacity. They are
Understood.
operating at a reduced
Understood.
capacity.
So they are operating in a reduced capacity and other 3 are under construction.
They are for under construction. So we are anyway not earning substantially from the under construction centers, but the ones which are actually functional, they have been working at a reduced capacity. That's where.
Noted, party. In the meanwhile, they discuss. The mediator also would like to ask: is there any willingness to negotiate on the 380 amount?
On the 380 amount,
380,
see, these are the losses we've already incurred. But let's see what they have
All
written
right,
on
yes.
the sleeves. But
Yes,
we
yes,
can.
it's your stage.
And you are also feel free if you want to discuss the numbers with us in private. If the parties want to do that, you are open to do that.
We'll keep it
also.
open. You discuss. You tell. You come up with if there is any reason that which you has come up to as to with respect to the 380 the figure, and also with respect to the DIS Act, we are more than happy to hear that out.
So basically, they are telling that DSI Act has actually affected them and caused so much of loss. And they want it to function so that they can recover from loss. So,
Okay. This is where I would like to alter our offers that are on our table. So, the DIS Act allows for an entity majorly owned by a localite of Samarika, right? We have understood that. And I also know that you are not a localite. So, what an option is from the government of Samarika is for an option of starting a joint venture, right? So in this joint venture, what basically we would like to establish is 51% of the ownership of the joint venture shall be taken by the government as per the DIS Act, and the other 49% shall be with NovaCap. So how I would like to incentivize this, because you have been working really hard and I don't want you to lose on this, right? So I really want you to reap the benefits of your work. So given that we have 6, let's treat this rather than a compensation, let's treat it as an investment from our end, right? So where there will be transfer of ownerships on how the data infrastructure is currently is, we can discuss. I want to have a discussion. I want to see how you are receptive to this idea. Transfer of ownership of the data infrastructure is something we can discuss. And I would like to keep it as a investment from my end rather than a compensation, as this would be a positive note for the future collaboration of our agreement.
So they have a proposal or an offer for you where you and the government together start a new joint venture which will be beneficial for you, is what the state is trying to tell. Would you like to discuss on it?
Just a small clarification as to understand how this particular joint venture is going to be different from an already accepted agreement that is between us right now.
So already there is a public-private partnership between the state and the NovaCap. So how will this joint venture be an additional incentive like you mentioned? If you can clarify and explain it further, it will be beneficial. Thank you.
I could have a minute to confer with my counsel, if
Sure,
that's okay?
please go ahead.
And at any time, parties, if you feel like you require a private caucus, you could please let us know.
Or break, or if you need something to make yourself comfortable also, let us know.
Thank you so much, Maya and Tharanya.
So to clarify how this new venture will work out as, that what we require is that 3 data centers would work towards client sector, and the 3 data centers would work towards the public sector. So we have joint infrastructure as in for now, but we will be dividing the data as per client and public. That is the main difference between it.
Okay. please go ahead.
Can I just clarify? I
Sure.
also draw inspiration for this offer from your 50-50 data split operation splits, right? And given that we want to have an oversight of how our citizens' data is being processed, which is why from a shared infrastructure, we want to segregate it. And as per your demands of having autonomy, which you already have in the current agreement over your commercial clients, shall also be maintained.
Also party, just a second, so we understand where both of you are coming from. So that is one offer on the table. I think it's very clear. As mediators, we have two suggestions from our ends. Again, it's completely not binding. It is up to your wish, but since you can have a right to listen to our suggestions, and then because at the end we want what is the best for you.
So this is open to state to discuss. So is that possible to give exception to NovaCap under the Act for the pre-existing projects? You need not do it for the new ones, but for the pre-existing, because we have a treaty signed with their country. So it is not binding, but per se, can you consider giving them an exception so that it is a win-win for both of you? You need not do it for the future, but for the present, which has been established since 1999. If you can consider doing that under your powers, is that an option that you can consider exploring?
There's just one more suggestion. This is again open to discussion because we completely don't know your internal regulations. Another suggestion can be that parties, since there is a requirement of a local agency, what you can do is you can delegate your work to a local agency, or in the terms of licensing, if you're understanding what I'm exactly saying, and then reap benefits from that, where it is the same thing because their loss will not be breached. Additionally, you are getting your profits because a local agency is involved, which involves delegation. So you can think about it for a minute if you want to. Now there are three offers on the desk. One is relating to the exception clause, second is relating to the license, and the third one given by them. Yes.
So you basically have future also, past also. You can take a minute to consider and then further discuss on this. Or if you come up with a newer solution, you feel free to discuss the same also. Thank you.
If you could give us a second, I think my counsel, Mr. Ali, had a point to state, and I think we'll take a 30-second break.
Take 1 minute, it's okay, please, because this is your future.
We understand. Thank you so much.
Take a minute and then you can get back. Are the parties okay? Comfortable?
Yeah, sure.
Yes. Who wants to go first? There's no coin toss and all. Yes,
All
yes.
Do you want to go ahead or
Just
shall I?
we'll go with a small quick question, and then you can take a collectively answer all those questions. First,
ahead.
with respect to the cross-border data exchange licensing point which you brought up, the data license clause which you stated, that is something which we wanted to come to, but I think slightly a bit later in the session. Before that, firstly, as Ms. Muskan I was discussing with, it's a really good proposal and something which highlights the 50-50 data operations split which we proposed. And we would like to walk on this path and discuss this in detail. However, before we start walking on that path, the one thing which we wanted to discuss, or something which kept on cluttering our mind, was what about the investments we have already done? Because those investments have already been liquidated and are there in the market. Are we providing with any exit clause for that? Are we providing with any sort of compliance rule for that? Or what about the investment which has already been made by NovaCap?
And in addition to what Mr. Ali has stated, I believe that if we go ahead with this joint venture, the agreement that is already existing, what happens with that is the crux of the matter right now. Like he rightly stated, we have invested a lot of money and we've also gone through a lot of losses. So we need to understand where we stand on a financial capacity in this particular agreement.
Parties, I hope you understood, or would you want one of us to summarize? Yes.
We are clear on that. So there are two facets to your query. I'll phrase it as a query. First is being the investment that is being 270 million, if I'm right, correct? And your financial capacity. Do you mean the 380 million or 270 million?
The investment of 270 million and the losses of 380 million. Now both have been liquidated, but especially the investment and more than that the losses. So yeah, you can take both of them too.
So just a second. Basically, they are stating that before we finalize one of the three solutions, what about the current status of the already existing agreement?
Before we looked into the solutions, we have to address these few key prominent points.
Noted, party, noted.
And I believe in addition to this, instead of getting into a joint venture, if we could just tweak up the current agreement, it would save us a lot of money and time, considering a lot has been happening and our company is certainly bleeding out.
Do you have any proposal of how to tweak it?
As Ms. Muskan stated, this is one proposal which we had on mind, but then we wanted to hear out with respect to the investments we've already
So
made.
to clarify, you want to continue the current agreement which is already in place?
With tweaks.
With tweaks,
Amendments, basically.
Yes, with amendments. If we are in a situation where our finances are at a good state, in the sense that if we are being indemnified or the amount of money that we have invested is returned in the sense that we're getting that money, then we're ready to go ahead with this particular agreement.
Understood, party. So before the solution, what about the current agreement? Is their question simply put?
Okay, so let me break it down like this. We have, I'm sorry, I'm going back to the 6 centers, but I feel it's important to break down the investment cost. So the total investment is 5 million, right? So for
500 million.
500 million.
That's
sorry.
okay.
500 million. For ease of calculation, let's just divide it into 3 and 3, that is half-half. So 3 data centers will have an investment of 250 million each, right? You have got.
No, I think it will be we'll be generalizing that far too much by dividing 3, 500, 250, 250. Then we'll say 50, 50, 50, 50. So I think that will be way too of generalization. But then because see already majority of it has already been invested, and still only 3 data centers have come up. Who are still under development and all. So I think that will be a bit more.
Okay, I'll tell you why I brought that up, right?
Sure.
So given the fact that you've completed 3, so let's just assume 250 has been gone there, okay? And the other, let's just assume, I'm not telling this is your actuals.
I mean, I understand, but as per the investment that is made, 3 have already been developed, correct?
I agree.
And 270 has already been invested. That 270 is used for the 3 development, because the other 2 are still under construction.
Yeah, I agree with all of that. So I'm just breaking it down for simplicity of calculation, all right? I'm not telling this is your actuals.
Definitely.
So let's see from a very simple aspect. So what I'm advocating for in a JV is basically it will protect your interest under the new act regime, right? Because you become a local entity, and your expectation or legitimacy, legitimate expectation also will get met, and you will be at a better position to be protected. Is what my intention is under a JV. Now, under the JV, what I am proposing is that we will take the ownership of 3 data centers, right? So for that, what we had previously offered was 300 million as an investment cost towards those 3 data centers, where we will take primary operations and supervisions, where you still will have a chance to operate the data centers and still work with our government. That way, we're ensuring that we still have an ongoing financial or business transaction where you have a chance to have a proper business opportunities, while the other 3, which you have already invested for, will remain in your operations as per the original contract. The entire purpose of bringing the JV is for 3 data centers operation and ownership.
I have 2 questions. If we go ahead with this, what happens to the other 3? That is, 2 are already under construction, and 1 is yet to be established properly. One is that. And secondly, as we have stated before, there is foreign client data that is also being stored in those particular data centers. So if we give full authority of those particular data centers to you, then we would be, I think, leveraging our clients' data that is stored in those particular data centers. And if there is a way where we can also, make sure that such client data is not leveraged, or in the sense that is not violated, then I think we are okay to go ahead and discuss it in.
For clarity, so we have 6 data centers right now, which is 3 functional and 3 under construction. So they are asking what is the status of the 3, and the state wants 3 of the data centers under their control and 3 to be in yours. Are you open to discuss which 3 will you will be having and which 3 they can have, or what are you trying to propose? Can you please clarify?
Understood, Pari. If I may just interject and clarify,
please.
I understand that in the data, you're okay with their proposal. However, your concern is that your foreign clients' data is also stored in these centers. Now, if there is a way to figure this out, then you're okay with this proposal. Now, the only question from the mediator side is there any specific data center in which only the foreign clients' information is stored, or is it
All the
amongst
3.
all, like amongst all the 6 or 3, the foreign is stored?
Just to give
Client.
crystal clarity on this, and I think as they rightly pointed out, there are 6. 3 are developed, 3 are functional, 3 are working, 3 are under construction.
Yes.
So the data centers which are under construction will not hold any data, to
Got it.
to
Got
put it very simply and outrightly. So we are just dealing with the 3 data centers which are functional. What, if I'm right, just correct me if I'm going wrong, what you have proposed is this, that you will be investing $300 million. In exchange for $300 million, you'll be taking over those 3 functional data centers. Am I right?
Do you want to take over the 3 functional data centers or any 3?
We're open to negotiations on that aspect.
All right.
Okay, and I think in addition to what my counsel has just stated, I believe the other 2 are under construction, but they have been suspended indefinitely. So even if we go ahead with this joint venture, wherein we're considering 3 fully operational data centers, then the other 2 where we have invested money, $300 million is not going to suffice that. So I believe we will have to figure out another way for this.
I think Saranya will agree with me that it is
Yeah.
better we have a private caucus with both of you, starting with the state. Can you please wait for 2 minutes?
I
Definitely.
request the
Thank you so
moderator
much.
to escort you, because
Thank you so much for understanding.
Thank you so much.
we have reached some progress, but we are stalling somewhere. To find out the hiccup, we are calling for the private caucus. I hope it's okay for both the parties.
Thank
This
you
will
so
be an
much. Thank you so
opportunity given to both the parties. I think 2.5 minutes per party would suffice
Yes.
to ensure 4 minutes. Okay, you have up to 4 minutes.
Oh, that's great.
You take a breather by then.
Thank you so much.
So how are you finding session so far? Are you comfortable about the process, how it is going? Do you need anything from our side?
No, I think we are making progress here.
Yes. So what are your actual concerns, or what are you looking in this forward in this mediation? What are the outcomes you expect it to be? And we have been pondering over the same again and again. Can you give us what you expect out of this and what needs to be done? Should we address anything in specific?
Yes. So, with regard to the offer that we are talking about, so they are also working with the defense AI, which emphasizes on the national security aspect of ours. So what we can do is, under the BIS Act itself, we can provide transitional assistance which can help them get the compensation. That is all we can provide to them.
if the mediator may just clarify, how much would that compensation amount to in numerical figures?
300 million, as we had discussed in the joint session. So let me give you more clarity on what we are facing as a country, right? Given the fact that we are a developing country, we are seeing constant interests for other investors to enter into the country, right? So this is why NovaCap is an important party for me, right? And like I told in the joint session, I'm very open about it. I don't want to terminate this agreement. Now, as far as the 3 operational data centers is priority or the primary purpose for which we entered into this agreement, I feel it is just to have at least 2 operational centers initially for the ownership of which being transferred under this joint venture,
So
right?
you want out of 3, 2 to be transferred, 2 functioning data centers to be transferred to the ownership of the government, state.
Right. So this is something they've already invested in, and it's already operational. So there's no extra money or expenditure they will incur on this, right? So the 300 million is what I'm offering as an incentive for them to speed up the development of the other 3 centers.
Not as a compensation. It is just an incentive.
Understood, Party.
Because I understand their party, right? They don't have the resource nor the power as a government as we do. And I want to accommodate them, and given the fact that it's one of their clear interests, I will go one step forward to offer that to them.
Understood, Party.
Is there anything else that you would like us to address?
You have roughly 30 seconds, so yeah.
To simplify what just Gitanjali just said, is that we would require 2 operational data centers.
Understood.
And one, we can talk about it later. Adding on to that, we'll be giving them $300 million in exchange of it.
So what about the foreign data that is there in these data centers? What is the status of that?
And also they had a question about the non-functional or the completely terminated data centers, because there was a stay put on that they cannot be operational again. If that is okay, can we discuss that in the joint session? Are you open to answering that question in the joint session?
Yes.
Thank you so much.
Please think about it. Thank you.
You can please wait for 4 minutes.
I request
We
the
request-
moderator to please call the requesting party.
Thank you so much.
Welcome back, parties.
Thank you so much for your patience.
How was your break? Good. Yes. So you have roughly 4 minutes. Firstly, you voice out your concerns. Also, please ensure we are ensuring you that in this private caucus, whatever is said shall not be revealed or disclosed to the other party unless you give us the green signal to do so. Please let us know.
Right. I think, firstly, I would put it out that we are operating under severe pressure from our board and limited partners. Firstly, because the data center project that we had invested in was our largest public-private venture in Asia. Firstly, and we had marketed it to the institutional investors as a guaranteed sovereign safe investment. Now, due to the current public policy changes, shocks, our current situation has impacted that a lot. Now, we are sending out a message when we say that we are guaranteed sovereign safe environment. However, the current situation doesn't state that. Firstly, that. Now, secondly, we actually we also intend to exit this asset if the mediation fails, because we believe that we have substantially put in a lot of money, and we are trying to have conversations with sovereign wealth funds from a third country to sell our shares, and any formal investment arbitration. If this mediation fails, we are going to go into investment arbitration, which would freeze our assets.
Understood. That is mandated by your clause 6.3 of the agreement.
Exactly.
Noted.
Now, if our assets are frozen and they become unsellable, then we will not be able to get back any money that we have currently invested.
So what are you expecting out of this mediation?
You can give a proposal. Once they are back, we will tell you their proposals.
We can share the
Yes.
offers.
Firstly, we were hoping that there have been violations that have happened, because we were assured that
Understood.
this agreement would not fail.
Yes,
and and we believe that our compensation of $380 million should materialize. And if that does not materialize, we will go ahead with the joint venture. However, we want to make sure that we have the operational hold over it, in the sense that the private party data that is stored will be held by us. We will be acknowledging over it.
The control over of your the
Private
control
client
over.
data.
Yes,
Yeah.
understood.
And the data that is of government will be held, the public citizen will be held by government. That is something we are okay to go ahead with.
Could you once again put it in 2 lines?
My counsel will
Yes,
be
yes.
doing that.
The data comprising private clients to stay along with NovaCap. The data with respect to the public entity shall stay with the government. That's point number one. If the second point, as Ms. Muskan stated, that if our compensation or the losses are not compensated for properly, then going ahead with the joint venture agreement might not be possible. If we are going ahead with the joint venture agreement, then these past liabilities has to be taken care of.
Clearly understood, Patty. Just to confirm, if the 380 million is not compensated, only then joint venture. Understood. What the mediators want to understand is, would you like to, or are you willing to come a step down or up with regards to 380 million? Are you negotiable on that? Because they have an offer, we'll call them and...
We are here to negotiate. We are absolutely fine with the negotiation, provided we are given certain other assurances that these losses don't incur and we are compensated in due future.
Quickly, we want to check if you want this conversation to be confidential, or we can discuss this with them.
The offers alone, they can be put up on the table?
The offers can be discussed, but I believe the...
Not your current situation.
Yes.
Understood.
Understood.
Thank you so
Thank
Your
you.
situation.
Thank you so much for your patience.
How was your break? Refreshing?
We were able to get back to our teams, and I think we have been able to refine our office.
Understood.
So, which I hope will serve as an incentive for the other representatives.
Understood. So from the private caucus, what we see is we both understand where you both actually come from. So there are certain offers by you on the table and also by them. We will brief out each other's offers to both of you, and then you can deliberate upon that. Just a quick reminder, we have around 7 minutes 30 seconds left for our joint session.
So the offer which is available on the table right now by the state is, they will provide you transition assistance and a 300 million, not as a compensation, but as an incentive for you to go on with your data center. And additionally, they want the in charge and ownership to be transferred of 2 data centers which are currently functioning to the government, that is the state. And remaining 1 can be discussed later. Is that clear, or do you want me to explain it again?
It is very clear.
That is very clear. I will now put your offers on the table for them, and then
Sure.
you can deliberate. Is that okay?
Sure.
So the offers from NovaCap is that, firstly, they are looking for the compensation. You can please correct me if I am wrong. So they are looking for a compensation amount of 380 million that they have suffered a loss. They are open to negotiation, I believe. Secondly, if that is not possible, their alternative is that they will proceed with your idea of joint venture. However, the data of the private citizens that is involved, they will have full operation and access to that data. Where there is public citizens' data and information involved, that will be in the access of the government.
No, instead of calling citizens, it's private clients and public clients.
Apologies, I stand corrected. Private clients and public clients.
Can you restate that offer again one more time, just for clarity?
Yes, definitely. I'm here, that's why only. Okay, so firstly, they are seeking for a compensation of 380 million. That is the loss that they are suffering. If that is, and they're open to negotiation because you're willing to give an amount of 300 million, 380 million, now that is open to negotiation, up to you. But if that does not go through, their alternative is that of the data centers that are existing, they will proceed with the joint venture. However, the data which includes of the private clients, that operation and storage and access will be with them. Wherever there is the involvement of public clients, since you're the state, you will have access to that. Now, this joint venture is only when the compensation amount does not go through. Is this correct? You have something to say?
Yeah.
Yes,
We had
proceed.
just one small question. for you, for the government. The first question being that your third proposal, which you stated with respect to the data center, with taking over the 2 data centers. When you're taking over the 2 data centers, are we differentiating between the data which those data centers will entail? In the sense that will you be taking over only those data which is with respect to the public citizens and the public governance, or even the private citizens' data or private clients' data? Will you be taking over that as well? Because that has not been differentiated. That was just one question, and then we'll go ahead and negotiate.
To clarify your point, we'd like to provide you with transitional assistance. Okay?
That was the first proposal. That's right.
Yes, right. So what we'll do is, we'll provide you with the private clients' data, including the foreign clients' data that you asking for, right? So we'll help you with this, and we'll require 2 years of time for the same, because we know that there is a lot of data that is being processed under that data centers. So what we require is, let me reiterate and simplify this offer. So as you know that there is an investment plan that we are planning for. So we seek 100 million from your side as an investment, and we will be giving 300 million for that particular data centers. So we will be taking 2 operational data centers and 1 will be non-operational data centers. And the restriction on the data centers that has been put will be removed. That is what we are telling.
I think the 100 million point is a greenhorn to this discussion. If you can kindly clarify, what does this 100 million,
So you basically want them to also invest 100 million, where you will also invest 300 million to make the data centers function, where they will be given rights to the private data.
Adding on to it, we have provided them with 40% of the private data. What we can do is, we can extend the limit of the 40% data to the 60% data that has been processed. So now they will have more data to process.
So for clarification, they have already invested 280 million. Additionally, you want them to invest 100 million to the same data centers which we are discussing.
For the
Am I
joint
right?
venture. Is that it?
This whole 100 million from.
Understood, part.
Secondly, when they state that they would give us 300 million and in return we invest 100 million, that is leaving us with $200 million. And even if we accept that and go ahead with it, we are running in losses. 270 was the initial investment. Then 200, I mean, if you do the math, I mean, my counsel would be better at it.
If I can add on, there was one part which was left in their offer. They also talk about the exit clause. So where they proposed if they can exit with the assets being liquidated. So that is also on the table. So
No, I think there are too many proposals on the table.
Yes.
Let's, look at one proposal at once. If that's not working, let's move to the another
Yes,
proposal.
Patti, I was just about to say the same. Right now, you're deliberating on the first proposal of the compensation or incentive, as you may call it, 300 along with 100 from your side. Now, if okay, we have 1 minute for the joint caucus,
Yeah.
joint session to
That's
end.
So let's keep it this way. We have 300 million from in their offer, where they expect you to put 100 million for the development of the data center. Are you negotiating?
I understand that it might not go through from both ends.
Go
so maybe you
through,
can
we will
just
be-
a second. Just a second. Maybe you can deliberate upon the second clause of joint venture, because that was your second proposal, correct? It
Or
was
you
an
can-
alternative.
Or you can go back to the original first offer given by them, that is the transition assistance, and 300 million for not as compensation but as incentive.
You also have
Can I just-
licensing and exemption clauses.
Right. So let me just break it down for you, right? I see that you're very confused. So let's break it down like this, right? Data transition has a cost, right? And we'll provide, so either we will provide you assistance under the scheme, under the act itself, which, okay, just to conclude, we will
Just-
provide,
How much time do we have for closing statements? Total of 10 minutes. Is it okay? Is it okay if we borrow 8 minutes from the closing statements and reserve 2 minutes for our closing statements?
I am okay with it.
Okay, 2 minutes to conclude and 6 minutes for closing. Is that okay?
Okay,
Please
let's-
keep it crisp, guys. We have
Yeah.
to reach something.
okay, so given that So let's stick to the 300 million. So I'll give you clarity on my first offer. Basically, what I'm telling is I'll give you 300 million as investment for the transfer of three of these data centers, two being operational, and one which is under development. So as far as the stay is concerned, given that we are taking majority of the interest or ownership, like a considerable amount of ownership, so what we would propose is that we will waive off the stay, right? So, but I also see that some of your foreign data has been withheld in the operational centers, right? But they aren't also working to their maximum capacity. So there is a possibility of transferring data from one center to another. So I understand this might take time for you, and during this process, I will assist you for the transition period. So all I'm suggesting is, provided you're able to segregate your private client's data, which will not compromise my citizens' data, what I will offer you at given the short limited time that we have is 300 million assistance for transferring the data from one of the operational centers wherever you have your client's data to the one that we were allocating to you, right? And how much ever time you would require for this. For this, we would like you to drop from 380 to 300.
I would like to make one statement and then my counsel would add on to it. Firstly, that it doesn't make sense, or we are on assumption that the private client data is only in one data center, and that is not possible. They are in different data centers. And
it requires segregation, basically.
Yes. And if we sit and keep transferring one data center's data to another, it is going to take a lot of time, which does not make sense, because you're going to be assisting us. You are losing out on a lot of money. We are losing out on a lot of time. That is more important. So I don't think that works out with us.
So the mediation session comes to an end. We would request the parties to make their closing statement in less than a minute.
I understand that there are concerns from both sides. There is some progress. We have leaped a lot, but there are some concerns still. I would request the parties to provide your closing statements for this session. However, since this is only the first session, we can reconvene in the next session as decided by you, and then finalize on the remaining undecided aspects. I request the requesting party to begin with your closing statements, and then the responding party, and then the mediators will close. Is that okay with both the parties? Proceed.
Okay. I had come here with a bad throat and a heavy heart, but I'm leaving on a much lighter note. So I really appreciate the fact that you have put down your point so simply so that we understand where we stand. So thank you for being supportive, and we hope we reach a solution in the further discussions or mediation sessions. Thank you so much for that, and thank you mediators for fine-tuning our...
Right. In a half hour, we have done more than what we could probably do in a courtroom for several months. So I think it was a great start. There are certain technicalities and other semantics which have to be looked into, and I'm sure that in the coming time, in the forthcoming sessions, we'll be looking at it with much closer clarity. And I think it would be wise for all of us to agree on what we all have come to thus far and leave few things in the forthcoming session. So with that, thank you so much for joining us at this session and initiating this conversation.
Right. Thank you, mediators, for conducting the session in a smooth manner. And both of us know how complicated the matter is, and sometimes I feel we don't understand ourselves as we talk about it. So I really commend your efforts to really grasp the situation in this 1.5 hours, and I really think that it deserves an applause for that. As far as NovaCap is concerned, rest assured you're a valuable partner. So it is my priority interest to continue this relationship. And I think we have sorted a few misunderstandings, and of course subject to further discussions, but I feel we have taken progress, and I hope this continues in further discussions.
Thank you, mediators. Thank you, requesting parties. I think we really value our partnership, and that's why we could come to so much of constructive dialogue. I see that there were certain points in the contract where we couldn't agree to. However, we took a step forward to find a solution. With that in mind and that in spirit, that we'll feel free to open discussion at the next session or find a solution. Thank you.
Thank you both the parties. It was good that you both engaged in good faith and active listening and open dialogue. That, as mediators, we appreciate it the most. So coming together is the beginning, staying together is the progress, working together is the success. So we have come together, we will stay together, we are progressing towards the success. Hopefully with another mediation session, we will be able to reach some middle ground. So this conversation has just begun the momentum towards a mutual agreement, and we hope that you, and are so thankful that you maintain the decorum and adhere to the ground rules which the mediators we set for you. And you have been very patient with us, adhering to all the things which we have also put forward with. And hopefully we see you in another fixed mediation session. We'll get back to you and we will fix a meeting where we can have another mediation session as well. So do your homework, come up with your interests which you want us to discuss in the next time. We hope that this conversation has helped you clear so many things which you have, differences and so many doubts that you had. Now that you have somewhere to work with, start working and let's get back soon.
So I see I have 25 seconds, 30 seconds, yes. So thank you both the parties for showing your willingness to engage in a mediation session. I see that through the discussion there are three common points. Firstly, there will be some sort of payment that will be made. Secondly, there would be some sort of data transfer. And thirdly, there is a possibility of joint venture. So from nowhere, we came somewhere, and it is important that we focus on what we have achieved. So we haven't reached a formal agreement today, but within the coming up sessions, 10 seconds please, we hope that we'll reach a formal settlement agreement. You were two banks of a river, but today the foundation of a bridge has been constructed. So let's take this momentum forward, and we thank you all.
And thank you so much, Sharanya. It is always a pleasure mediating with you. With that, have a good evening. Thank you for being here with us today.
The mediation session comes to an end. Thank you,
Thank you.
parties.
Thank you, teams. It was an absolutely engaging and enriching session filled with strategic negotiation and collaborative problem solving. We kindly request the judges to provide their valuable feedback on the session and the performance of the participants.
Yes, good evening. It is very good event, and I really appreciate you. At this young age, we have entered into a new arena. In our time, we did not know what is mediation in our time, but in this modern days, at this young age, you are presenting a very good skill in the mediation process. I hope there is a future in India. Brilliantly exercised, a blessing from all of you. And I pose one question to mediators. You mediators are mediating both requesting party and the responding party, and there is some dispute between them. My question is, what effort you have made to make both parties to some conclusion? Some issues are there. The dispute between Nova Cab Company and the Samardhika state. And you being the mediators, what efforts you have made for both parties to arrive at some conclusion? In that process, what issues you have raised? Because there is a voluminous dispute is there, and some other dispute. In what way you are able to identify that issue and convey to the both parties to come to such a particular conclusion? Yes, please.
So the issue here was there were multiple issues. There were financial financial problems involved, and
No, maybe there are some core issues are there. Some core issues are there. So, how you were able to convey the core issues to both parties, making both parties to come to some conclusion. It is in this way, the role of mediator is very important. So, what effort you have made?
Understood, sir.
Ah.
Yeah, actually, we suggested two proposals regarding a licensing agreement that they can do or an exemption clause, but that was not actually debated upon right now because the issues they had were of a much larger interest. So we asked them because in this case, there's a local government, a local body that should be involved for them to invest their data and money. But since that is not allowed, that is why we asked them either they can give them an exception clause because this is an age-old agreement, or they could have given an sub-delegation that could have happened by giving a license to another authority. But they were completely discussing about the compensation aspect, so that proposal never came to a agreement.
we could not address the other issues because they were persistent about their issues already.
That is
So
of utmost importance.
we tried to channelize them, but if that is what party wants and if they were already discussing, so we wanted to at least clear the air between them so that we can further negotiate on terms.
Good, very good. All of you have performed excellently, excellent performance by youngsters, and really the legal field will have a bright future at your hands. Thank you very much.
Thank you so much, sir.
So, well done, all of you. It was really interesting to see the younger generation participate in mediation, which is a very complex topic. But seeing the interest and seeing your understanding of the complex problem in such a short time and trying to solve it or at least lead it to a kind of a conclusion was really nice. So just one small thing that I just wanted to tell. When I left home, my daughter asked me, have you studied mediation in college? So like Sir said, we had absolutely no idea of what mediation was, and we evolve. With every stage of learning, we evolve, and that is how we realize that mediation can also be built into a system which can be recognized as an effective dispute resolution mechanism. So very well done, and I think at your age, having this, I would say, capability and understanding of this complex case and trying to close it within 1.5 hours needed a lot of effort. And I know that as mediators, you said that it will continue, which I had also imagined because such a complex matter cannot be closed in one session. But that said, very well done. I think the clarity of thought, communication, and presentation was really good. Keep it up.
Thank you so much, sir.
We extend our heartfelt gratitude to our esteemed judges for their invaluable time, expertise, and constructive feedback, which serves as a guiding light for all participants. We now request the audience to rise as all dignitaries leave the auditorium. I request Vaishali to escort the dignitaries to the boardroom. audience to be seated.
Hello. So now we have arranged one photography session outside the auditorium. I kindly request you guys to leave according to your team code. To follow Surjit sir. Guys, kindly rise and move according to the instructions. A small reminder to all the team managers, make sure that you are seated in the team codes according to your team codes, which are labeled on the chair. I kindly request all the team managers and participants to make it fast. Please be seated fast.
TC17, TC17, and TC4. Could you please report to the stage? Yes.
Good evening, ladies and gentlemen. May I kindly request everyone to rise as we welcome our esteemed dignitaries onto the stage. We kindly request the dignitaries to occupy the seats on the dais. Thank you, everyone. Please be seated.
Esteemed dignitaries, luminaries of the law, and the very architects of tomorrow's justice. It is with profound pride and immense joy that we welcome you to the valedictory ceremony of the International Commercial Law Mediation Competition 2025.
It is an absolute privilege to be your host this evening. I am Anushka from 2nd LLB, joined by Alexander from 4th BBA LLB. Today, we come together to celebrate intellect, collaboration, and the transformative power of mediation, the very foundation of the effective dispute resolution.
This competition has been a testament to the power of dialogue in legal practice. We have witnessed some of the finest young minds from across India engage in mediation with remarkable dedication and professionalism. It has been an enriching and inspiring experience, and we extend our heartfelt gratitude to each of you for making this event a grand success.
To commence this special occasion, it is our honor to invite our esteemed director, Reverend Father Gerald de Souza SJ, to address the gathering.
Dignitaries on the dais, faculty, my dear students, good evening to all of you gathered here. We are at the end of another meaningful exercise, a constructive event. We have spent 2 days in very useful or perhaps productive listening, learning, and also mediating. It was nice to witness your enthusiasm, your eagerness to learn, and perhaps the skills of communication, the confidence, and the research that you have done on the given topic. And that is giving us a tremendous sense of hope, as already Justice told us in his observation, that this is a development or a positive development with the young minds, with the tremendous sense of confidence. They can communicate the things that they are aware of. Secondly, I would look at this issue with a tremendous sense of hope when people are losing in a way, or perhaps getting disappointed with the traditional judiciary because of the delay and because of sense of lack of participation in the process. I believe mediation will give a different path, perhaps, to move forward and settle the issues amicably, speedily, and with a firm sense of justice. With this, I would like to congratulate you once again for your active participation and very eagerness for learning, and perhaps with the great sense of responsibility that you have taken part in this event. I would like to acknowledge the contribution of ALMT Legal for their assistance, for their presence, and being the judge this evening, for encouraging a student as well. I'm also grateful to Justice Anchate Sanjeev Kumar, Judge High Court of Karnataka, for being with us, spending this time judging the event, and also he will guide us, especially the young minds, how to take forward this profession with a deep sense of commitment and deep sense of justice. I'm also grateful to Mr. Prashant, the advocate, who is an expert in this field, who will talk to us on this importance and significance of mediation. My special thanks to our faculty coordinators, Surya and Sujit, and also all the student coordinators and our ever active volunteers. I am also grateful to all the faculty and the support staff for the meticulous planning and execution of this event. Let our search for knowledge and justice continue through such events and processes. Thank you once again, and God bless us all.
Thank you, Director, for your invaluable words of wisdom.
We now invite our student coordinator, Ms. Manaswi, to introduce our esteemed chief guest, Honorable Sri Justice Hanchate Sanjeev Kumar.
Thank you, Alex. Good evening, everyone. It's a privilege to introduce our chief guest, Honorable Justice Hanchate Sanjeev Kumar, a distinguished judge of Karnataka High Court. Justice Sanjeev Kumar's journey in law, marked by dedication and excellence, has been an inspiration to many. Born on May 13, 1971 in Ilkal, Bagalkot district, he completed his BSc and law studies before beginning his law career in 1996. With expertise in civil, criminal, revenue, and labor law, he practiced in various courts and tribunals. Justice Sanjeev Kumar has served in multiple districts across Karnataka and played a significant role in making justice accessible as a member secretary of the Karnataka State Legal Service Authority. Since becoming a judge of the Karnataka High Court in 2020, he has delivered landmark judgments including on maintenance rights for wives and fair compensation in accidental claims. Please join me in welcoming Honorable Justice Hanchate Sanjeev Kumar with a big round of applause.
Sir, we would like you to join us and enrich our students with few words.
Good evening to all. Sri Prashant Chandra, a remote advocate and a mediator trainer across the country and author of a commercial court book. Mr. Satish Srinivasan, a great mediator in the country. Reverend Father Gerald D'Souza, Sri Prashant Sikoria, Principal, Miss Shobha Hegde, and all my dear children, and other distinguished lecturers, teachers of this great institution. I beg pardon, my communication may not be clear due to health affected 2 years before. But as far as possible, I convey my thoughts. Please bear with me. First of all, I feel privileged to be part of this great event organized by this great institution, a very prestigious institution in the entire country. I must express my gratitude inviting me to become part of this event. And I witnessed a great performance by the students here in such a complex issue. When I was a student, I never heard of this mediation, commercial court, etc. Just Section 89 was there in the Code Civil Procedure, but it was not in much practice during my early years of practice and when I was a student. But really today, I am highly impressed upon seeing the performance of students on the mediation subject. Really, there is a paradigm shift in the legal arena. Just I am told that in India, on an average, there is a success rate of 50% which matter go to mediation. And in Bangalore, the success rate is more than 60%, 65%. This is the big shift in resolve a dispute outside the court of law. So, a very great event organized. I think it is one of the unique event organized by this institution on mediation subject among the students. Therefore, I congratulate all the students and participants in this event. Really, I am very impressed. I do not talk much about the mediation and commercial courts because I have requested Mr. Prasant Chandra to speak on the subject. I am on the litigation side. I am not in the area of ADR except Lok Adalat, because in mediation and in conciliation and arbitration, there is no role by judges. In Lok Adalat, in Lok Adalat, we judges are sitting in Lok Adalat. Therefore, out of 4 methods of ADR, the judge participates in Lok Adalat only, in mediation, in arbitration. In arbitration, they are after retirement of service, but not during service. But really, what I have learnt about mediation and what we have got training in mediation, the real mediation I witnessed today in this institution. The performance is good and a brilliant performance by all the students. Let me convey some of my few thoughts on the legal profession. You are all my children. My daughter studying in this institution in second LLB. So, with feeling of affectionate towards you, please allow me to convey some of my thoughts. My thoughts are not new to you. You know very well. but just I am reiterating the same principles. But the important, being when you are being a student of law, and within 2 or 3 years, you are entering to the ocean of practice of law. Therefore, these few thoughts may help you in future. For the benefit of students, I created one website. Creation does not mean that creation outside, but it is a imaginary, just conveying the thoughts effectively. The website address is hish.ll.rrr, and another one is rr.wd. Why this essential is, judiciary always needs efficient advocate and competent judge. I don't know whom you become a great advocate or a judge, but these qualities must be inherent in every student of law. hish.ll.rrr means H stands for honesty, I stands for integrity, S stands for sincerity, and H stands for hard work. LL means law and language. Then the 3 R's, rigorous, reading, and research. This should be the hallmark of every lawyer, especially for those young advocates like you. The other one is RR.WT, means read, recollect, write, and discuss. These qualities are very important for every students of law during their college level and after completion of their education, entered into the field of law, either maybe in litigation side or maybe non-litigation side. See, the concept of law is not new to the India after independence. If we trace back to Krita Yuga, Ramayana, there was rule of law. In Vasishtha Ramayana, Maharshi Vasishtha preaches the values of governance of the state and how to administer justice to Lord Rama. See, what we witnessed in British era, the jury system, it was in those days. The king was administering justice, the mantris are juries. In those days, dharma, what we now call it law at that time, dharma. It was not codified law, codified dharma, but written in scriptures, in a text, shastras, dharma shastras. In ancient India, law was mainly based on morality. After time passes, now the said dharma was changed, the name it as a law. Now we have codified law. So law and dharma are not two different entities. They are one subject. In what way? In Bhagavad Gita, in the Bible, in the Vachanas, in the Shastras, we see the values the same values we see in law in codified law forms. We have a great text, Dharma Shastras, Vasishtha Ramayana, Vidaraniti, Bhishmaniti, Chanakya, Arthashastra, Varahamihira, Vijnaneshwara, Dayabag, Marmakatayam, so and so. The list goes on. So, the administration of justice is not new to India. From medieval India, the law is codified. But before that, the law, the dharma, mainly based on moral values. So, we have given, we Indians, we Bharatiyas have given to the entire world how to administer justice, in what effective way we should govern the state. This is the text, this is the idea, concept of law we have given to the whole world. Law is not an empty formality, law is in both science and art. In what way law is science means, in what way a scientist make a research in a laboratory by thinking rigorously on a given subject. In that passion, every lawyer should study the law, make in-depth study, science, then its application, effective presentation application is an art before the court or before the mediators or some other persons. Therefore, law is both science and art. See, I can give some examples because I am telling on a practical side. For example, if a case comes to you, you have to make a thorough study on the facts of the case. Unless you master of the facts, you cannot present the case effectively. The law will take its own course in the court. The judge knows law. But the advocate should know on all aspects, on all 360-degree angles, what is the factual in the case. The effective presentation of the case before the court or before any ADR mechanism process. The effective presentation of case depends upon in what way you are studying the facts in a case. For that, you have to make counseling of your client, receiving informations, particulars, all the facts, documents, evidence. Then only you can effectively present the case before the court. I give an example. The difference between filing a original suit and a writ petition. For filing writ petition before under Article 226 of the Constitution, it is easy compared to drafting plaint and WS, letter statement. In the writ petition, you simply need to state the facts along with the documents. But because in the writ petition, there is no scope for disputed facts. But in a civil suit, while drafting a plaint, you have to be very careful. Though you are a student of law, but within 2 or 3 years, you may enter into a senior office, you go to the court, and then you will come across what is plaint, what is statement. Now you are studying only on the theoretical aspect. But when you enter into the profession field, you have to know the importance of plaint and WS. And also, claiming relief in the plaint is very much essential, the appropriate relief. Whether it is suit for mandatory injunction, permanent injunction, or only for possession or declaration. These aspects are very important for every lawyer. Therefore, be thorough on the facts in a given case. Then only you are able to present the case effectively in the court of law or in any other EDR methods. Number one. Number two, read thoroughly the Evidence Act. The Evidence Act is nothing but a codified, crystallized common sense. Evidence Act is nothing but common sense, but it is in a codified, crystallized codified form, Evidence Act. Because we are seeing, because of improper presentation of the plaint before the court, improper presentation of evidence before the court, improper relief asked in the plaint, the party loses his case. The client do not know in what way he is going to present the case, but the advocate should know in what way a case must be presented before the court. That is why we have to be thoroughly, you have to make a thorough study on the facts. The LL, I need not say what is SISJ. S stands for hard work, integrity, sincerity, and hard work. But regarding hard work, I must say something. Nowadays, there is a misnomer. Why should you do hard work? I can do smart work. Smart work does not mean that reducing the hours of working hours. Do hard work, do work, not hard, do work, but with all smartness by making use of the new technologies emerged in the modern world. There is no substitute for hard work. The law profession is not a bank job from 10 to 6. Whenever you want to gain success in your profession, you have to do hard work. At least you have to work 14 hours a day. 14 hours a day. Then only you will be successful in this profession. And the other important aspect is become master in the definitions of each act. Unless you know the definitions well, unless you are good in definitions, in understanding definitions, you will not be able to understand the act properly. For example, in the Evidence Act, the word used is relevant. It is a very difficult to understand what is relevant. Unless you apply your mind in a logical and logical thinking way and in a practical sense, you cannot understand what is the meaning of relevancy, as put in section 3 of Bharatiya Saksha Adhiniyama or word section 5. In every act, the definition, Transfer Property Act, Contract Act, Hindu law, in every aspect, in every case, the definition. You must study the definitions. You must understand the definitions well. Then only you will become master over the subject. This is the importance of studying your definitions in depth. And moreover, the RRR and LL. LL means law and language. Law means be thorough on the law. And language means a good presentation of case, a well flourished language, both verbal and in written. While drafting plaint or petitions or written statement, the language must be very polite and attractive, impressive. And likewise, in the court of law or before ADR platform, the language must be a smooth, polite, sober, having all good qualities. So this stands for the importance of L and L. And then comes to RRR, rigorous reading, rigorous thinking. This is very important. Also rigorous research, because research. Therefore, unless you, because the advocates are called as learned advocates. Doctors are not called as learned doctors. Engineers are not called as learned engineers. The only profession we call the advocates as a learned advocates, because the law is a continuous learning process. Continuous learning process. You have to study the law, journals, acts, and the recent judgments of the High Court and Supreme Court. This is the importance of rigorous reading and rigorous research. If you improve these qualities, if you cultivate these qualities in your profession, surely you will become a legal luminary in your field. You see, Mr. Prashant Chandra is here, a very remarkable advocate, and he is author of the book Commercial Court Act. He is very thorough on Commercial Court Act. Today and yesterday, what you have participated in the event Mediation and Commercial Law, that I requested Mr. Prashant Chandra to address you, to give some insight into that area. But these HISH.LL.RRR, RR.WD, these must be inherent quality of every law students. Sir, Dinsha Mullah, you might have heard the name Dinsha Mullah, Mullah's Hindu law, Mullah's Modern law, Mullah's contract law, everything. Sir, Dinsha Mullah said regarding the law students, I quote, the whole future of a student of law depends largely on the kind of books placed in his hands for study. So what quality of books you have in your hand for study, that decides your success. Sir Dinsha Mullah said about a century ago on the young advocates in those days. So the extensive reading and extensive research is essential and necessary for every lawyer, even for law students also. Then, then the important thing is, nowadays, every student is studying law in a reputed colleges. St. Joseph College is one of the such a great institution. Please do not carry in your mind that I have come out from the institution, I have studied a 5 years law course, I am a good medalist, I secured rank, I am a best advocate, I participated in several moot courts and won prizes, and I knew everything. Don't carry this impression in your mind. What you study law in college is only 25%, not 100%. What we study in law colleges, that is only 25% of the whole learning of law. The remaining 75, among them 25, you learn the remaining 25 from your senior's office. Sitting in a senior's office, studying the case law, studying the facts, applying your legal knowledge in the chamber of senior, in the office of senior, then you study 20%, another 20%. Then other 20% you are going to learn in the code campuses. In the code campus means attending the courts, sitting in the courts, not in canteen. The remaining 20% attending the courts, observing the court proceedings, what advocates are arguing the case, what judge asking the question, and what is the answer, and what is the examination chief, what is the cross examination, how the evidence are tendered, documents are tendered, what is the leading questions asking, observing the court proceedings, you will learn 20% of law. So 20% college, 25% in your senior's chamber office, 20% in court halls, court. Then the final remaining 20% you will learn law by observing phenomena in the society and the nation at international level. By keenly observing the developments in society, you will learn law. I recommend all the students, please read Advocacy, Principles and Practice by R.K. Sonawala. So, madam, do you have copy of it in college? R.K. Sonawala. You have? Yes, very good. I request you, go to library, because the copy is not available in market. Go to library and study the book titled as Advocacy, Principles and Practice by R.K. Sonawala. Please remember this important point. So, advocacy requires a continuous study. Continuous study. The role of advocates is immense in shaping India, in protecting and in developing India. See, the immense contribution of advocates in protecting our India, we can see in Keshananda Bharati case. All you have heard the name of Keshananda Bharati and you have studied, and there is a very popular doctrine, basic structure of the constitution. Yes? From whom it is evolved? From whom? It is because of the brilliant argument made by the advocates, headed by Rani Palkhiwala. See, Ishananda Bharati case should be studied in the background of the then political situations. If the judgment in a Keshana Bharati case is not there, then what India today would not have been, would not have been. I don't know if that judgment had not come, if there is no occasion for a Keshana Bharati case, then surely what we are now enjoying the status in a country, we don't have today. That judgment saved India. That case is maybe simply regarding land reforms, some bill or act challenging this bill. But not only that particular facts, it was a struggle between claiming supremacy by the Supreme Court and the Parliament. Ultimately, it was held Constitution Supreme, and the basic structure cannot be amended. So this is the contribution made by the great advocates. That's why I call the advocate as the saviors of India. That is called as advocates or social engineers. So the contribution of advocates were immense, very important. I request you, read the legal classic books, legal classics. Then your legal maturity will be augmented. Studying legal classics, reading legal classics, and making research on the law makes you a more legally matured person. Then you will be satisfied with yourself. How lies a noble profession. Therefore, I appeal to you all, follow these principles: HISH, LL, RRR, RRWD. Finally, I request you, kindly adopt the qualities, values to the Constitution as your life principles. What the principles stated in the preamble of Constitution, we should adopt in our life, personal life. The Constitution is not a mere book, it is a living organism. Supreme Court says, when the principles of Constitution, especially in the preamble and in fundamental duties, it is stated, if we cultivate the principles in our life, then surely there will be a strong judiciary and vibrant India. Therefore, it is essential to cultivate in ourselves the principles of the preamble and the fundamental duties should be our life qualities. And law is not a mere just a profession. It is a service to justice. We are seeing great advocates. I can quote one example, how the advocates are serving the society. A great advocate, he is now here in Bangalore, Mr. Ken Puttekoda. Now he has given a practice to Delhi Health, but being an advocate for Brahat Bangalore Mahanagara Palike, he saved from land mafia 1,000 crores of rupees property The property is worth of 7,000 crores is saved for Bangalore people. Otherwise, we would not have seen such number of parks, lakes. This is the contribution made advocates to the society. I have quoted two examples, one Kesambarthi case and this case. So therefore, the advocacy is not a mere profession, but it is a service of justice. Directly service to the society and nation. So in this way, we should have significance of law in our mind. I hope we carry forward a message to others and also to inculcate in your life. And if you really follow the principles, I hope you will become a great lawyers. You become an efficient advocate. You become a competent judge. Where there is a fight between efficient advocate and a competent judge, then there would be a best judgment. The judgments really serve the society and nation. See the judges on Supreme Court. Many judgments are there. You are studying very well. If I quote something, I quote the Kesambarthi case and Mindara Mills case, and recently case Puttasamigada case, that is right to privacy case, triple talaq case, and ban of child labor, ban of smoking in public places. All these because of Supreme Court judgments. The lawyer's contribution is immense in involving these type of judgments. So whatever the best judgment comes to the court, it is because of hard work by the advocates. Therefore, the law is both science and art. Therefore, I wish we should become an efficient advocate and a competent judge in future. I once again express my sincere gratitude to this great institution inviting me to become a part of this event, and really I witnessed excellent performance by the students in the event. The issue was so complex, but the students in a very short span of time studied the shared case law very well and effectively presented. And this is one of the unique events this institution organized. Therefore, I congratulate you all, and also once again by expressing much gratitude, I conclude my speech. Thank you. Jai Hind, Jai Namaskara, Jai Karnataka. Namaste.
Thank you, sir, for your enlightening words. We now invite our student coordinator, Ms. Sagarika, to introduce our distinguished partner, Dr. Satish Srinivasan.
Thank you, Anushka. It is our privilege to introduce Dr. Satish Srinivasan, partner at ALMT Legal and a distinguished legal expert with over 25 years of experience. He holds a bachelor's in commerce, master's in personal management, and LLB from the University of Pune after graduating from Symbiosis Law School. In recognition of his contribution to law and social service, he has been awarded an honorary doctorate. Dr. Srinivasan specializes in corporate law, joint ventures, M&A, FEMA compliances, and advising clients across sectors like defense, aerospace, and technology startups. A trained mediator, He actively promotes alternative dispute resolution and has played a key role in resolving cross-border and domestic disputes. Deeply engaged in international legal practices, he has helped establish over 125 companies, primarily from Europe, leveraging his expertise in German language and culture to build strong client relationships. Ladies and gentlemen, please join me in welcoming Dr. Satish Srinivasan. I now request Dr. Satish Srinivasan to speak a few words.
Good evening, everyone. I hope I would not take more than 10 minutes of yours. Thank you, St. Joseph's College, for hosting this event. It has been a pleasure being here and truly an honor to address you at this valedictory function. I would like to start by saying that I happened to fall into the area of mediation by accident. So it so happened that we were dealing with a German client and he wanted to file a recovery suit. And we started the process, and midway somewhere we felt that the matter is going nowhere. So we just kind of deliberated and discussed with him, can we consider mediation? So the client was not happy. He said, why are you trying to deviate from where we started? So we just explained in a 2-hour session as to what are the pros and cons of litigation versus mediation. And they said, okay, since you're trying to convince us, let's kind of jump into it. So when we started the process of mediation, I would say we had earmarked 3 full days for the session. And the client had to come from Germany, the technical expert had to come from Vietnam, and the opposite side was from India. So organizing a meeting with everyone present together was really a Herculean task, but we did it. And in 2 days, in 6 hours, we could settle the dispute. So it was an eye-opener for me, and I said, wow, this is quite fast. And the client asked me 3 times, is that all? So I said, yes, I mean, you've got your relief, and it concluded in the way you wanted. That said, what I would like to say is over the years, I've had a privilege of handling several cross-border mediation matters. It has been really challenging because you need to understand 2 cultures, sometimes speak the other language, because I do a lot of work with Germany. I also speak German, so I have to speak in English, German, and translate sometimes nuances of where we are heading. But what I have seen is in Bangalore, there is a growing awareness of mediation with more businesses, professionals, and even courts recognizing the value. However, we still have a long way to go in terms of building the path where perhaps I think Prashant sir will give more explanation. But in terms of cross-border, what I have seen is it is a very preferred mechanism because legal costs abroad are very expensive, and there are certain institutions like Singapore International Mediation Center, International Chamber of Commerce are all offering specialized mediation courts. Law firms are also setting up specialized practice areas in ADR mechanisms, and there is a lot of scope in this field. So just to conclude quickly, because I know you all are having a tiring day today, I just needed to emphasize on the importance of 3 things, which I think Justice Hanchate has already explained in detail. But as young lawyers, I would always encourage you all to develop 3 essential skills that are foundation to just not mediation, but for the legal practice as a whole. The importance of reading. Reading expands your mind and strengthens your analytical attitude. Beyond legal texts, read literature, psychology, and history, more so when you practice mediation, because all of this becomes very important in your process. And understanding human nature is as important as understanding law. Second is the art of clear communication. Legal jargon does not win you cases. Clarity does. So whether you're drafting an agreement, arguing in court, or mediating a dispute, your ability to convey your thoughts with precision and simplicity is key. Too often, lawyers believe complexity reflects intelligence. I'm sure as law students, you also write complex answer scripts so that it confuses the teacher who's correcting it as well. But I think the crux of it is, as long as you're clear and convey what you want to convey clearly, it simplifies it to the reader. The last part is the art of listening. So in an age of constant distractions, true listening has become rare. As lawyers and mediators, listening is your most powerful tool. A well-placed pause, an acknowledgement of the other person's perspective, which I think in today's round we saw that in the participants. Ability to read between the lines can make all the difference in resolving a dispute. Active listening does not only build trust, but also helps uncover underlying interests that lead to meaningful resolutions. So to conclude, to all you young lawyers today, you are the future of the legal profession. Whether you choose litigation, corporate law, or mediation, remember that law is not just about rules and arguments, it is about people. Mediation offers an incredible opportunity to make a real impact, to resolve conflicts, and to create solutions where none seem possible. I commend each of you for taking part in this competition and for embracing the values of mediation. I hope some of you will go on to become pioneers in the field, bringing greater peace and resolution to the legal landscape. Thank you and all the best.
Thank you, Dr. Satish Srinivasan, for your insightful words. It is our pleasure to invite our student coordinator, Ms. Manaswi, to introduce our esteemed guest of honor, Mr. Prashant Chandra, SN.
It is with great pride and immense respect that I have the honor of introducing our distinguished guest of honor today, Advocate Prashant Chandra SN, stalwart in the legal fraternity whose career spans over 3 decades and 3.5 decades. After becoming an advocate in 1987, he has subsequently established a distinguished practice in civil, commercial, high court, family court, and tribunal cases, with a particular emphasis on the new and important field of alternate dispute resolution. He is a partner at the esteemed law firm Law and Options based in Bangalore. As a trained mediator and a trainer of trainers, his work in mediation has been truly path-breaking. He has played a vital role in pre-institution mediations under the Commercial Courts Act 2015 and continues to contribute extensively through pre-mediation, private mediation, online mediation, and community mediation initiatives. He is also a dynamic communicator running a popular YouTube channel titled Vakilara Vahini and serving as the editor-in-chief of the bilingual legal magazine by the same name. His contributions to legal literature include the acclaimed book Commentary on the Commercial Court Act 2015. Please join me in extending a warm welcome to our chief guest, Advocate Prashant Chandra, a visionary teacher, a mediator, a true pillar of the legal community. Now I request Advocate Prashant to address the gathering.
Namaste. Good evening. Thank you. At the outset, I thank the institution for having this opportunity to share my few thoughts on the concept of mediation, concept of Commercial Courts Act. I am conscious of the time factor. I personally thanked Justice Anchate for having given me an opportunity to share the dais with him. Justice Anchate, sir, Satish, my friend, Reverend Father Gerald, Reverend Father Prashant. I am also a Father Prashant, but not I'm Reverend. And Madam Principal and Madam Vice Principal and the ADR committee. How many of you are watching IPL regularly? Please raise your hand. Good. How many of you are RCB fans? More than the IPL watchers. Good. How is cricket relevant to mediation? That's the question. Okay, before I go further, you're all now studying in your law, maybe 3 years, 5 years. How many of you intend to take up litigation practice? Please raise your hand. Okay. That means to say less than 50%. Anyway, I would like to say one thing before I go further. Today we had 2 judges judging your competition for the final and few others in the morning and yesterday. I was also part of some deliberation which took place in the finals. I have seen the performance of the mediators in particular. I would say hats off to them. Please give a big hand to whoever it is. They were good in communication skills, confirming, we call it as confirmation at the end of the session. I think one is here and one is there. I'm just watching them also. And we say restatement, reframing. These are all the techniques which we use in mediation, and all those techniques have been used by them in the last 15 minutes when I was sitting there. Their demeanor was excellent, body language was excellent, and they performed very well. Of course, this is a time-bound one. Naturally, you have to be within the time. That too, when the 2 senior judges, one real judge and one another friend of mine who is a good mediator before you, they are there. Your job was excellent. And particularly, I like you because thinking on your shoes. In a mediation where I do, nobody knows what I do. I have my plenty of time. But you had to think on the shoes and ask the person to say how long you have the time, adjust accordingly. And the last ending statement, closing statement was perfect. You left it open in a positive note and gave an impression that you can continue further though the competition gets over. I wish if they are available, you have time, maybe if not today, online, just continue for the sake of it. Thank you. I would only like to say what Justice Sanchate had said and Mr. Satish had said. What took me 20 years to understand the mediation, you have learned at your age of 20. Thank you. Good luck. As I was coming, I was just thinking about the dispute resolution. Every dispute had to go to a court, civil, criminal, whatever be it. We are all governed by something called a Civil Procedure Code. It is of the year 1908. We had in 1940 a new act coming as Arbitration Act. See, please note, I'm not getting into the detail for want of time. In 32 years after the new procedure code was introduced, they brought in an amendment in the nature of an Arbitration Act to divert the court cases to the arbitration. Is it not privatization? Please note, even before independence, the privatization had started. 1949, we had the 47, I think, Industrial Disputes Act. Just look at, I think, 10A section. It also speaks about conciliation. 1947, we had the independence. 1950, we had our constitution. 1984, we had something called as Legal Services Authorities Act, which Lordship has already referred. That was a new concept to diversify and reduce the workload on the existing judiciary and give more parallel, alternative, effective mechanism. That was a success. It is a success even today. If you go and see your newspaper, maybe 2 days back, you see 5,000 cases are disposed of, 25,000 cases are disposed of in Lok Adalat. We call it Lok Adalat. Then we had the amendment to the Civil Procedure Code 17/2002, wherein for the first time we heard the word mediation. Please see, before that we had some amendment in the form of a new Arbitration and Conciliation Act, which repealed the 1940 Act and brought in a new concept of Arbitration and Conciliation Act, and in that section 30 referred to again mediation. But what was that mediation? Nobody knew. We thought that a policeman doing some dispute resolution is mediation. Some senior man in the house doing with his younger relatives, that is mediation. No. Now we are learning what is mediation. We had thereafter so many things coming in favor of mediation. We had the Salem Bar Association case where the Lordships, then Supreme Court, held as to what is mediation. Salem Bar 2, there was another judgment by the Supreme Court. Thereafter, another by Justice Ravindran from this place, Karnataka, who said about, in Afghan's constructions case, about the role of all the ADRs, arbitration, conciliation, mediation, Lok Adalat, judicial settlement. Please see, arbitration, conciliation, Lok Adalat, they have their own statute. These were recognized as alternative to Section 89, in Section 89. Mediation, as I said, was unheard of. In other words, when mediation was introduced in 2002 for the first time, it came as a non-starter. Nobody knew. As I said, mediation or a middleman was the same. I have a house, I need to sell it, I need to go to a broker. He was also called as a mediator, though he is not a mediator. Mediation was just introduced and they said it's voluntary, optional. You need not accept it, it's up to you. Later we had some amendments coming in other acts like Companies Act, Consumer Protection Act, etc., where slowly they brought in the concept of mediation introduced there. Then came this Commercial Courts Act 2015, with effect from 23/10/2015. For the first time, we had a statute on mediation, which is called as pre-institution mediation. Please see the difference. Mediation came as with no background, only as an optional, informal. Later, the same mediation has become compulsory in Commercial Courts Act. Please see the comparison. Arbitration, conciliation, Lok Adalat, they are already doing a lot of work. They are already parallel to the judicial system. But the parliamentarians did not say pre-institution arbitration, pre-institution conciliation, pre-institution Lok Adalat. Why did they say only mediation? That itself makes it very clear that mediation has something very core in it, fundamental in it, which is different from other mechanisms. Therefore, in 2002, which it came as a guest appearance, now is become main actor now. Thanks to the institution. Imagine all these years, the discussion or the moot court would have been on some other subject. Now, wherever I go, I only see mediation being the subject of competition everywhere. It's good because now, thanks to the institution, you're all getting exposure to new laws, new mechanisms. I'm very conscious, I have very little time left, but still I would like to say, mediation is a game changer. Pre-institution mediation is a game changer. You have the dispute which could be resolved before going to the court through mediation. And you can always settle the matter in mediation. If you're not happy with the mediation, you're not getting the desired result, nothing stops you from going to the court, which was otherwise different in the earlier scenario. You had to go to the court. I have a dispute with Mr. Satish regarding, say, 1 lakh rupees. Maybe I have sent a notice, he has replied. There is a denial of my money demanded. I had no other go but to go to the court. But thanks to mediation now, those litigations can be easily resolved here. If really it requires some serious adjudication, then only such cases can go to commercial court, not otherwise. So I can go on this because that's my pet subject. I've been dealing with this from the last 20 years. Mediation is a litigant-friendly process. We have heard of this eco-friendly, consumer-friendly, that-friendly, reader-friendly. I would say it is a success because the parties have the choice here. As I could see your own parties in the mediation, they had the liberty to speak and get what they wanted. It was they who were important in mediation. You are facilitating as mediators, giving them the opportunity to participate and make the best out of the negotiation. Coming back to this live mediation here, one thought which I thought I can also request the organizers. Confidentiality aspect probably was not very seriously followed here because you had to use the mic. You had kept one party out. They are not supposed to hear, but it happens. Otherwise, I think it was an excellent demonstration of mediation. That may also be kindly taken note of next time. You can keep the separate room without there being any. Maybe you can try that. That could be taken care of. So mediation is a voluntary, confidential, neutral third-party process. The success of mediation is because it is neutral third party who is officiating. That's the key to the success of mediation. I will only end with this. We have only 5 crore cases left in the Supreme Court and the courts in India. Only 5 crore cases. As I'm ending my statement, it could be a little more. It will only take 325 years more to dispose of the existing 5 crore cases. And there are only 15 lakh advocates to deal with it. Please see. I'm only speaking from my perspective, not from Justice Anchate's perspective. That is to say, if there are 5 crore cases, at least there should be 10 crore advocates. You will have obviously at least 2 parties in a case, minimum. Which means each advocate has about 600 to 700 cases of an average. Why I'm saying this is, these 5 crore cases is only 30% of the existing disputes. Rest of the 70%, they are not even entering the court building. They're not wanting to litigate because they know that this is not possible for them. Thanks to this commercial court concept, where the cases are being disposed of very effectively faster. Thanks to this process of mediation, now the people are approaching the courts. I am saying with my experience that commercial courts, first level, second level, third level cases are getting over in a span of 3 years, which is a record in Indian history, legal history. Whereas you have the other cases which is taking 30 years. So the law on commercial court has been the cause for the change in the outlook of all the litigants in India, and that's the plus point for you, the youngsters. An average 50,000 people are getting registered every year as advocates. How many of them are going to practice? I'm not sure, but I would only like to say, in continuation of what Justice Anchate said, complementing what he has said, there is abundant scope for practice. If you have any other ideas, think about practicing first. That's what he says. The fundamentals are good when you are practicing. Practice. Be under a good senior. You have already done hard work and you are now in the stage where you are completing your course. Continue the hard work for few more years, maybe another 5 years. With the way you are all coming up with your intelligence, you are far better than all of us, I'm telling you. The day is not far when you will have abundance in you. This is the future for you. The future of India is in your hands. The average Indian age is 29. The average age of a lawyer in India is 40. You are in the bracket even earlier to that, which means you have another 30, 40 years of professional life ahead of you. Be proud that your parents or yourself have put you into this profession, into this education. Don't worry if your doctor friend or engineering friend is earning more. That's all temporary. You'll earn much more here. More satisfaction, job satisfaction, you will have it. You have plenty of time. The future is yours. The future of India is in your hands. Mediation, take it as a passion. You will have your best days to come. Thank you very much.
Thank you, Prashant sir, for your exciting words about the world of mediation. We are truly grateful to our esteemed guests for their profound insights and words of encouragement. Now I invite our faculty coordinator, Professor Surjit Rahulji, to take over the awards and winner ceremony.
Good evening, everyone. I know we are running a bit late, so without any further ado, let's begin. So beginning with the most important certificates, participation certificates. So I invite Reverend Father Jael D'Souza SJ, our chief guest, Honorable Sri Justice Hanchate Shivkumar, to please come forward and deliver these participation certificates. And teams, I will call out your team codes and your college. So I think you already know what to do, so please be a little fast, right? Okay, so starting with TC1, IFIM Law School. TC3, SRM Institute of Science and Technology. TC5, Kristu Jayanti College of Law. TC5, Kristu Jayanti College of Law. TC6, Alliance University. TC7, Government Law College, Trivandrum. TC8, Soundarya Law College. TC8, Soundarya Law College. TC9, Ramaya College of Law, Bangalore. TC10, Manipal Law School. PC2, RV Studies, Institute of Legal Studies. PC11, Christu Jayanti College of Law. PC12, NMIMS Kirit P. Mehta School of Law. PC14, Christu Jayanti College of Law. PC16, SRM Institute of Science and Technology. PC18, Ramaya College of Law, Bengaluru. PC19, BMS College of Law. PC20, Tamil Nadu National Law University. PC21, Tamil Nadu National Law University, Team 2. PC22, Bangalore Institute of Legal Studies. PC23, NMIMS School of Law, Mumbai. PC25, SVKM's Narsi Monji Institute of Management Studies, Bangalore. PC26, KLE Law College, Bangalore. TC27, Woxon University. 27 is not here. TC28, TC28, National University of Advanced Legal Studies. PC 31, IFIM Law School. PC 13, CMR School of Legal Studies. PC 13. PC 32, Ramaya College of Law, Bengaluru. PC 13, PMR School of Legal Studies. Thank you, Father. Thank you, Justice. So, moving on to our semi-finalists, I invite our Finance Officer, Reverend Father Prashant Sekwere ASJ, and our Principal, Ms. Shobha Hegde, to felicitate the semi-finalist teams. So, semi-finalists, starting with the mediating pair, PC 9 from Ramaya College of Bengaluru, and TC 2 from IFIM Law School. The mediators, PC 13 from CMR School of Legal Studies, and PC 21 from Tamil Nadu National Law University. Okay, sorry. Team, TC2, RV Institute of Legal Studies. I'm sorry. Mediator TC13. Mediator TC21. TC21. Right. So finally, thank you, Father. Thank you, ma'am. So moving on to our most awaited awards, moving on to our winners and runners-up awards. I request, starting with the runners-up mediator, I request Vice Principal Shobha Hegde and Finance Officer Reverend Father Prashant Sekwera to present the runners-up mediator awards. So the runners-up mediators are PC1, Narmada Raghunath from IFIM Law School. Thank you, Father. For the runners-up mediating pair, I invite Mr. Prashant Chandra Essen and Dr. Satish Srinivasan to please come and felicitate the runners. So the runners-up mediating pair is TC 23, Muskan Mishra and Ali Murtuza Mosby from NMIMS School of Law, Mumbai. The runners-up mediating pair take their position by a margin of just 0.5 marks. Now, thank you, sir. Now, moving on to the best mediator, I invite Honorable Justice Hanchate Sanjeev Kumar and Principal Dr. Pauline Priya to present the award for the best mediator. So, the best mediator, after 2 days of intense competition, has been selected. I don't think there is any surprise. I am sure you all already calculate. TC25, Cheruvu Amrita Saranya, SVKM's Narsi Monji Institute of Management Studies, Bangalore. A big round of applause for the best mediator, please. Thank you, ma'am. For the best mediating pair, I invite Honorable Justice Hanchate Sanjeev Kumar and Director Reverend Father Gerald D'Souza SJ to present the award for the best mediating pair. The best mediating pair is finally TC18, Geetanjali C. Kannan and Vanshika Sanchwani, Ramayana College of Law, Bangalore. Another round of applause, please. Thank you, Father. Thank you, Justice. Thank you, everyone. Now,
as we approach the conclusion of this distinguished gathering, we take this moment to express our sincere gratitude to our esteemed guests of the day for their invaluable presence and contributions.
We now invite our Director, Principal, and Vice Principal to felicitate our distinguished Chief Guest, Honorable Justice Hanchate Sanjeev Kumar, in recognition of his invaluable presence and contribution.
we now invite our esteemed finance officer, Reverend Father Prashant Sequeira SJ, to present a token of gratitude to Dr. Satish Srinivasan in recognition of his invaluable presence and unwavering support.
A final mention must be made of our guest of honor, Mr. Prashant Chandra, who has graciously requested that no token of appreciation be presented. However, sir, your wise and guiding words have been truly invaluable to this gathering. Thank you, sir.
To express our heartfelt gratitude to everyone who contributed to the success of this grand event, I now invite our esteemed faculty coordinator, Professor Surjit Rahulji, to deliver the word of thanks.
Good evening, everyone. I know we're all tired, exhausted, and eager to leave. But before we conclude, it is only right that we take a moment to express our heartfelt gratitude to everyone who has supported us in making this event a grand success. First and foremost, I extend my deepest gratitude to our chief guest, Justice Hanchate Sanjeev Kumar, and our guest of honor, Advocate Prashant Chandra. Thank you both for gracing us with your presence and for sharing your invaluable insights into mediation and legal practice. Your words have been truly enlightening and inspiring. I cannot emphasize enough how grateful we are to our incredibly supportive knowledge partners at ALMT, represented here by Dr. Satish Srinivasan. Your team, consisting of Mr. Nikit Bala, Mr. Prashant Popat, and yourself, has been a creative force behind the challenging and thought-provoking problems that our participants no doubt had fun solving. We sincerely appreciate each one of you for your invaluable contribution. Thank you, sir. No event in our college would be possible without the unwavering support of our management. I extend my heartfelt thanks to our director, Reverend Father Gerald D'Souza SJ, our principal, Dr. Pauline Priya S., our vice principal, Ms. Shobha Hegde, and our finance officer, Reverend Father Prashant Sequeira SJ, for their continuous guidance and encouragement. Thank you, ma'am. A special note of appreciation to Mr. Balraj for facilitating all our purchases, Mr. Maxim for the seamless stage and auditorium arrangements, Mr. Tipesh for handling the sound and lighting systems, Mr. Yesuraj for the photography and live streaming support. I would also like to acknowledge our maintenance staff whose dedication and support ensure that our classrooms and event spaces were well organized and well maintained. It is because of all of you that we were able to conduct this event so smoothly. To our esteemed faculty members, your guidance has been invaluable. Without you, we would be lost. Many of you rearranged your schedules for us, while others went above and beyond to support this endeavor, staying back for long periods of time. Thank you for standing by our side every step of the way. A special thank you from the depths of our hearts to our incredible student volunteers. Your tireless efforts made this event possible. Your dedication, energy, and teamwork have been instrumental in ensuring everything ran seamlessly. An even bigger thank you to our organizing committee, whose spontaneity, resourcefulness, and problem-solving skills have been at the heart of this event's success. I must also acknowledge the prime movers behind this event. As I invite, I also request them to come to the stage and take a photo with the chief guests and the dignitaries. My co-coordinator, Ms. Surya, who has once again declined to take the spotlight here, and our dedicated student coordinators, Mr. Yasser, Ms. Anushka, Ms. Sagarika, Mr. Alexander, Ms. Navika, and Ms. Manasvi. It's okay. Your dedication, energy, and teamwork have been instrumental in ensuring everything ran seamlessly. You've all worked relentlessly day and night to bring this event to life. As we reach the end of this journey, I congratulate every member of this team, including myself, for all that we have accomplished. It has been truly a wonderful and rewarding process. Last but certainly not the least, I express my gratitude to all our participants. Thank you for joining us over the past 2 days and for making this event a vibrant and engaging experience. This event would not have been possible without the contribution of every single person mentioned above in this speech. And with that, I close by asking all of you to give a huge round of applause for everyone who has made this event a reality. Thank you, everyone.
As we draw this memorable evening to a close, may I kindly request everyone to rise for the national anthem.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you. Please remain standing as our esteemed dignitaries exit the auditorium.
On behalf of St. Joseph College of Law, we extend our deepest appreciation to each of you for your invaluable contributions to this prestigious competition. Your enthusiasm, dedication, and commitment to the spirit of mediation have made this event truly extraordinary.
As we bid farewell, we warmly invite you to join us for refreshment. Everyone, if there's, kindly reach out to us with respect to certificates and cash prize.
All right, thank you very much, participants. A real quick announcement, please collect your refreshments. But apart from that, if you have any issues relating to your certificates, spellings, names, etc., please reach out to me right now. Cash prize winners, reach out to me again and provide your details. Lastly,